Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
I started getting the passion again, so I don't know, I think I want to go back to being a lawyer.
I want to be a lawyer.
But can they get to law school? Well, that could depend on an affirmative action case before the U.S. Supreme Court. The future of diversity in legal education? We're on location from the Camden Public Schools and from the State Bar's annual meeting. Legal education on the line on this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
Welcome to Due Process. If you've seen us before, you'll know this is not our usual set, nor our usual noise level, because for this show and the next, we're with you from the State Bar's annual meeting in Atlantic City. I'm Raymond Brown.
And I'm Sandy King. It's crowded and it's loud, but for a few days each May, it is the center of the state's legal community. Just yesterday here, we saw the passing of the torch from one leader to another and the installation of KAROL Corbin Walker as the State Bar's first black president. We saw a retiring Supreme Court justice honored, the first African-American justice, James Coleman, and we saw the debate of issues from medical malpractice and handling the media to racial profiling post 9/11. We also saw a spirited session on a question being debated across the country. What will the U.S. Supreme Court do about affirmative action? How will it decide the pending Michigan case? And what will that mean for diversity in higher education and especially our law schools?
We'll put that question to 3 of the people we just saw, the deans of 2 of the state's 3 law schools and the first black president of the State Bar, who says she owes her success in part to affirmative action. But first, Sandy takes a look at one special group of law students from Rutgers Law School, Camden.
Raymond, they not only go to Rutgers-Camden, they're making a difference in the city of Camden by bringing the law to some Camden high school students. Just the kind of kids for whom the Michigan case could have some serious consequences.
What case tells us that, Ty? What case tells us silence is protected?
West Virginia versus Barnett.
Yeah.
All right.
Supreme Court cases and concepts.
The 2 main components of due process. Mike.
Notification, and opportunity to be heard. Now we're back.
The Constitution.
And we're talking about what amendment?
The first.
And what does the First Amendment protect?
Not the usual stuff of an inner city high school, but this is no usual class.
For 15. For 15? Ding, 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 ding. That's the double jeopardy.
These kids really are learning law.
I'm learning about politics, the Constitution, laws, how they made, how they get broken.
Learning from teachers who are students themselves. Law students spending a unique semester in the Camden Public Schools. A semester marked by unorthodox teaching methods.
What is going on in here?
Hello, Ms. Herring, principal of Camden High School.
Mr. Costello, why aren't you keeping order in this class? What is this all about? I don't understand.
From role play, an angry principal confronting a student's peace protest.
I'm thinking that you did this. I'm thinking that you're responsible and that, you know, your freedom of speech is only pushed so far. No?
No, this is a form of how we want to express ourselves.
To Jeopardy.
Give me a due for 10. Give me my due for 10.
All part of a program named for 2 late Supreme Court justices. Thurgood Marshall, who first made his mark in civil rights law, and William Brennan Jr., whose roots, like Rutgers-Camden, where these teachers go to law school, were in New Jersey.
Thurgood Marshall and Justice Brennan, they knew that we needed to get the education out there and in the public schools, in the secondary schools.
So when I found out that we had an opportunity to teach constitutional law to students in high school, I just thought it would be just an amazing opportunity.
An opportunity for both sides of the classroom.
It shows me that someone other than our teacher cares about us, like the students from Rutgers Law.
I just can't thank them enough for what they've done. They've really broken the Constitution down.
And created an excitement they may not always find in school.
I got it. Wait, this right here.
You know, you hope that some kids, you know, maybe will want to be attorneys or will want to go into teaching or something because they see that we're excited to be here and, you know, that we believe in them.
People who really want to be lawyers, like, it'll get them in track for college, so they'll know exactly, you know, how it is. They'll be ready.
I like to argue, and I like to express my opinions, and being a lawyer, you can do that.
Where's the line?
When you pass, well, you have the potential to do something harmful to somebody.
No, you should have the right to say what you want. Everyone is not going to agree with what you say at one point in time.
So Asia, where's the line?
There should not be any line.
Just an idea of maybe this isn't right. Maybe I should speak up about something or think about something or become more involved in my community. I hope that's what comes out.
And that's it. And good job today, guys. All right. Thank you.
Everyone say hello to the camera.
Hi.
Well, the idea then to bring knowledge of their basic rights to the kids who may need that knowledge most. And of course, there is always the hope that some of the high school kids will reach for the chance to be lawyers themselves, a chance that could become even slimmer depending on how the court rules on Michigan.
And that's just where we'll pick it up, here in the exhibit hall of the State Bar Association's annual meeting with the deans of 2 of New Jersey's law schools and the newly installed president of the New Jersey Bar. So stay with us.
A conservative-leaning Supreme Court with George Bush at the helm. It's just my suspicion that it is going to be overturned.
I think that it's a wake-up call for the universities, for the academics, to understand that education has nothing to do with race or money.
This is not a utopia, and everything is not even-fielded. You know, we all know that. So it's needed. There's no need to change it, and I don't think that they will.
I can understand where affirmative action needs to be addressed, especially in getting into colleges, but it's a tough argument, so I really can't say one way or another.
It is from affirmative action, and they're trying to abolish it. It's the end of the story for them. And it'll be the end of the story for us if it happens.
But will affirmative action in law schools survive the Michigan case? For some answers, we turn to RAYMAN Solomon, Dean of Rutgers Law School in Camden, to Seton Hall's Law Dean Patrick Hobbs, and to KAROL Corbin Walker, the new State Bar President, who says affirmative action made all the difference for her. Welcome to all of you.
Thank you.
KAROL, I've got to turn to you in part because of the reason that we're here. Last night at a very special event, the governor, the Chief Justice, many dignitaries were here paying tribute to you and what you've accomplished, and it raises a question that is often involved in the affirmative action debate. Does affirmative action stigmatize those who benefit from it?
A resounding no. Affirmative action does not stigmatize anyone who has benefited by the results of it. I am a perfect living example. Notwithstanding many obstacles and the ability that I've had to endure to do certain things, affirmative action has made the difference for me in my professional career. And I have never felt any lesser than I am because I benefited from that. In fact, I have benefited tremendously, and that's not...
More specifically, even before you became head of the bar, would you have gotten into law school but for Seton Hall's outreach in terms of affirmative action?
Well, the difference with Seton Hall's outreach is not it's not necessarily just purely affirmative action, because Dean Hobbs is here and he can discuss that. But the program that they have at Seton Hall is one that is encouraging people to participate in if they're educational deprived, financially deprived, or handicapped. And because of that program, you have people participate in it who are just not people of color.
But let me ask you a question. Do you think that you would have gone to law school but for the idea of affirmative action?
No.
Okay. Dean Hobbs, that leads us to a natural question. I teach at Seton Hall. My wife's a graduate. But Seton Hall is in the heart of Newark. I think that your percentage of African-American students, about 5-6%, somewhere in that range. Is that a number that you've consciously striven for? Do you want a higher number? How do you feel about those numbers in terms of affirmative action?
We want a higher number. You mentioned the community that we're a part of, Newark. We're also part of the broader New Jersey legal community. The demands of the bar are for diversification. Every year in the New Jersey Lawyers Journal, Lawyer, you see the statistics that there are not enough African Americans represented in the major firms, not enough partners in the major firms. And so they look back to the law schools, both Seton Hall and to Rutgers, to provide a growing talent pool for those firms. So we have to do a better job than we're currently doing.
Dean Solomon, your percentage is about the same down at Rutgers-Camden, I think. Do you have a view about where you want to be in terms of numbers of African-American students?
We'd always like to increase it. We don't have a specific target each year. Each year the pool is different. Each year we're trying to find talented students who want to come.
Now, I take it that both of you have programs in which race is a factor, among others, that you consider in the process.
Correct.
And the reason we're talking about the Michigan case is because the Supreme Court is now considering, as we speak, whether or not race is going to continue to be a valid factor considered in the admissions process. If schools like yours, which are really trying hard to get numbers, are at the 5-6% range, although I think Rutgers-Newark has been at about 14% for some time, how do we expect this to impact on the students of the kind we saw in that report at the beginning of the show, young African-American kids who want to go to law school? What's the likelihood of impact if the Supreme Court says you can't consider race as part of the admissions process?
If the Supreme Court overturns Bakke, it will have a devastating effect. I mean, we have the history of the California law schools, which, when told that race could not be used as a factor through state initiative, the numbers plummeted of minority students in those schools. They're now creeping up a little bit, but it would be a devastating effect if the Supreme Court said absolutely that race could not be used as a factor, because for two reasons. I mean, both because of what we would be able to do, but also because it sends a message, as your question to Carol pointed out, that you're not welcome, which is certainly not a message that we think should be sent, certainly not by the Supreme Court of the United States.
And that's the concern, is the message that's sent. When Hopwood and these other decisions came out, it sent the message to students of color, you're not welcome in higher education. And just like Rutgers-Camden and Rutgers-Newark, Seton Hall looks at the entirety of the student. It's educational disadvantage. Our summer program that Carol came in through is about educational disadvantage. Now that has disproportionately benefited students of color coming to law school. To be told that this one factor cannot be a criteria that you should examine in really providing kind of a rich environment, not just in the law school, but after law school in terms of the legal community we create, it disturbs me.
What's the prediction then about what the Supreme Court's going to do? Do any of you have a strong feeling either way? It's obviously tremendously controversial and there's much discussion in the legal community, but what's your best guess?
Well, the one thing I think we can be certain of is we don't know for sure what they're going to do, and then probably, I assume the decision will come down within the next 6 weeks. My best guess is that there will be a majority for upholding Bakke, Justice Powell's opinion in Bakke, and that, however, they will not, I don't know about the Michigan Law School, but probably the undergraduate program will be struck down, and they will try and tailor it. They will require that we have a more narrowly tailored program.
And now, one of the contrasts that I was curious about is that you're in Newark and you're part of the Rutgers University system. Rutgers-Newark has about 15% African-American students. Do we know why there's a difference in terms of their numbers as opposed to either Seton Hall or Rutgers-Camden?
they've had various programs over time. I mean, they had a program which I think started even before Bakke. I mean, I think goes way back, and so they have a longer track record. They have, I think, within it is the dominant public university in the New York area. They have a very large pool. They've been very aggressive, and I think that's what explains what they've done.
Given these, let me ask Carol, what do you think about the future? Does the future, given the path you've taken and tried to inspire other kids to take, even at the current environment, we've got 5% at 2 schools there where we have strong ties. What do you think is going to be the future, especially if the Supreme Court says race has to play a limited role in admissions in the future?
If the Supreme Court decides that race should play a limited role, I think, again, I agree with Dean Solomon, that would have a devastating effect on the lack of numbers you would see, and it would impede one's ability to even try to get into law school. I think that sometimes as a society we look at the wrong issue. Right now you talk about affirmative action within the structure of the law schools. There are so many preferences out here that we don't talk about as a society. You have the athletic one with Title IX. You have the legacy one. You have one whose parents may have donated to a school. I suspect if we start looking at those and filing Supreme Court cases with that aspect of it, then we could really have a discussion that would be valid. But
Is there anything in your year that you can do, assuming that the Supreme Court doesn't roll back the barrier, I mean, doesn't roll back Bakke? Is there anything that you can do in the State Bar to encourage larger numbers of African Americans to apply and push numbers higher at the law schools?
Well, through the New Jersey, actually there's a group in New Jersey called the New Jersey Law Firm Group that the law schools are a part of, as well as medium and large law firms and corporations in New Jersey. The primary goal of that group is to increase the diversity in those various sectors. Within the Bar Association, we have a Minorities in Profession section. We have a Diversity Task Force section that deals very closely with the law schools, and through our foundation, we outreach to the community. So I would say that with all of those components, we would be able to get the word out, to encourage people to still apply to schools, notwithstanding what would happen.
Now let me go to a context that I think most people won't know about. That all of this is happening at a time when there are astronomical increases in admissions and applications to law schools. What's the number or the percentage of increases in applications to Seton Hall?
It's incredible. I mean, this year we're experiencing a 30% increase in applications. Last year there was a 25% increase. And over a 5-year period, I think both at Rutgers-Camden and Seton Hall, it's a 100% increase in applications.
What is the cause of that?
Well, a couple of things. One, you've got the economy's changed. So fewer people are coming out and going to the dot-coms. They're going to think about professional education. Demographic. There's more 22-year-olds today than there were 5 years ago. And I think there's a growing interest in the practice of law again. I think September 11th played a role in that. The idea of the rule of law and the value of the rule of law is starting to inspire more of the high school and college kids to think about law as a profession.
But let me put this in context. In Due Process's first year, we did a program about the increasing number of people coming out of law schools that it threatened to swamp the legal economy in terms of job availability. Now, you're involved, Carol, on the day-to-day involvement with all of the major law firms and the small ones around the state. Are there enough jobs to employ the young law students that are going to come tumbling out of Camden and Rutgers and Seton Hall?
I say there is. I don't believe that we are at a point in our legal environment where there's not enough jobs.
But let me just, do both of you agree that the legal economy will easily absorb
I think
100% increase?
No, I think one of the, you talked about, you're mixing two things here. You talked about increase in application. Right. The number of lawyers we're graduating has been relatively constant.
But your enrollments are increasing. I know Seton Hall enrollment increased last year.
That was not.
But society is forcing you to adapt to some extent, is it not?
Well,
let me give two statistics.
Yeah, okay.
All right. One, and I think our numbers are similar. 98% of our graduates were employed last year within 6 months of graduation. So the jobs are out there. And then something that I heard recently, which I hope is true.
But is that going to continue? If 2 years? Okay.
Here's the second statistic. Within the next 10 years, 1/2 of the lawyers in the employ of the federal government will retire. Now, they're going to have to be replaced. And so I see, as this baby boom generation moves to retirement, there's going to be a tremendous demand for more people to come into the practice of law, be it in the government sector or the private sector.
And the slowdown may be at the large firms, which are dealing with directly with corporate clients, I mean, the needs of individuals for legal services has not diminished in our society, and there is plenty of opportunity, I think, for people in smaller firms, more practicing, doing more individual counseling.
Then let me bring the conversation back to where we started, because one of the things that's happened in the focus on the affirmative action case has been a stronger look everybody's taking at the segregation that continues at primary educational levels and the disproportionately poor education that many minority kids are getting. So if there's greater pressure for a more competitive student body to get admissions, if there is a Supreme Court that says you can't consider race, what happens to minority kids as this crescendo builds and they're not able to gain admissions to these universities? What are the social consequences when we know that black lawyers, for example, have been active in social movements in America?
See, Ray, I'm more optimistic. One, I think the court is going to give us what they've always given us, and that's muddle. There's a reason I became a tax lawyer, not a constitutional lawyer, because I don't like the muddle. And I'm optimistic about what we're going to do, because I think the law schools all understand what the needs of the community are going to be. And unless the court, which it's not going to do, comes out and says you have to use the LSAT, the admissions test.
By muddle, you were saying that the court has not been real clear in terms of its affirmative. Okay.
I don't think that they're going to come out with a prescriptive saying you've got to use the LSAT. And that's what I think CIR and all these other litigants want. They want something based purely on the LSAT. The LSAT, by Law School Admissions Council itself, says it's not the best predictor in law school. At certain points in it, it's a good predictor. So we're going to find a way as law schools to make sure that we have a diverse community of students and that we provide a diverse group of graduates to the bar. And I'm very optimistic about that.
Are you equally optimistic? Given the fact that we face continued segregation and poor schooling at primary and secondary levels for black kids, and that it looks like the law school environment and probably the law environment generally are going to be more competitive, how do you remain optimistic?
I remain optimistic because I agree wholeheartedly with Dean Hobbs, because I think that the Supreme Court would be constrained in a way not to say that race can be a factor as long as it is not the factor. And I agree wholeheartedly with what Dean Hobbs talked about, is that the benchmark with the LSAT scores. If LSAT scores were the only determining factor when Seton Hall looked at my application.
Of course, but let's remember that we were not happy with Bakke. We thought that Bakke, the current environment, was a step backwards because it really said only to get diversity can you talk about and consider race, and you can't have quotas of any kind, which is why the Michigan case is up, because people say it looks like that. Even if there's a Hobbesian muddle, and I think many people agree there might be, it seems to me that that's going to at least make it tighter, make it more difficult to use race.
But what we've actually seen, though, is that 25 plus years of experience is that while we may not have been happy with what Bakke gave us, we've been able to take it and work within it, its rules and its constraints, and I think develop programs which are not perfect, but which have made a lot of progress and which have helped open the door to a whole generation of African American and Hispanic lawyers.
Let me try to give Karol the last word. You were talking about the undergraduate program at Michigan, one which uses numbers and is maybe more vulnerable before the court, but has preferences for people who live in areas where there aren't blacks and which have been attacked for other grounds. Overall, you remain optimistic that in a broader sense, education will continue to be diverse no matter what this court does in terms of the undergraduate case?
I am, although I'm an optimistic person, I could not ascribe to that view that no matter what the court does, we would not have a problem with increasing diversity. I think we might have a problem with increasing diversity, but as long as the undergraduate universities and colleges are ever vigilant to develop programs that enable them to achieve their same goal,
you still feel free going to schools in Jersey City, where you and I were born, and Camden and Newark, and telling black kids that they have a shot to be lawyers?
Absolutely, because I believe that a child can be anything they want to be, and they're only limited by their imagination. So I would wholeheartedly continue to do that.
And I take it you share her enthusiasm.
Absolutely.
And optimism.
I do too.
I want to thank you all for being with us. This has been a special day. That's it for this special edition of Due Process, but we'll be back next week with the second of our two shows here on location at the State Bar Association's annual meeting. Till then, for Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
I hope each student just kind of walks away with an opportunity to think of things a little bit differently. I don't think that we're going to be able to teach them all of constitutional law in a semester. I don't think you can even do that in law school, but just an idea of maybe this isn't right. Maybe I should speak up about something or think about something or become more involved in my community.
You know, you hope that some kids, maybe will want to be attorneys or will want to go into teaching or something because they see that we're excited to be here and, that we believe in them. That was actually a big thing too. Like, we're always trying to tell them that, that we believe in them and that they're good kids and they're smart kids, because I don't think they hear that enough sometimes.
Major funding for due process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,